reaction to the fact that your client was found guilty of murder?
Well, I think it's a tragedy. A lot of people say, are you surprised? Yes, I'm surprised as can be. We really strongly believe that we didn't play on a level playing field. We have given notice of intent to appeal. We believe that we have a lot of issues to appeal from. This jury made a decision. I think if this jury had been able to hear some of the witnesses that we intended to call that were not allowed to testify, I think if they would have heard some of the testimony we sought to elicit from some of the officers on cross-examination, which we were not allowed to do, I think if the jury had heard all this, the outcome would more than likely have been different. And so we're saying that we believe that there's enough error in this trial, and we really feel strong. It's not something we're doing to make the family feel better. We believe there's enough there to cause a Court of Criminal Appeals to take a serious look at reversing this case. And we look forward to starting that appeal process. We've ordered the transcript already. We've already paid monies on it. We anticipate that we'll try to get it out as fast as possible. We're looking at probably from today's date till maybe 18 months at the earliest that we'll hear a decision. So Mr. Ersland is going to stay in custody during that time. And I think he's getting stronger, actually, while he's in there, and I think he can endure. We had a good discussion this morning. So I said we're looking forward to appealing this case.
Mr. Box, following the sentence, what did your client tell you?
He just said, keep up the work, and I'm looking forward to seeing the appellate brief and your brief for the appeal on this case.
What witnesses did you not get a chance to call?
We had several witnesses that we wanted to call, like pharmacists that had been victims of robberies. We had a police officer that a few months after this case shot and killed someone during a non-violent crime, a 25-year veteran that we wanted to call to see what was in the mind. We wanted to show the jury the state of mind of a person confronted by armed, masked men. And as I said, we had some pharmacists that had been victims of robberies. We had the officer that had shot someone that wasn't masked in broad daylight. We thought that those people who had been in a situation like that is not as strong as Mr. Ersland's, that he had done and taken actions, that they should be able to testify to tell this jury, look, this is what goes through someone's mind. We wanted to be able to get illicit cross-examination from the officers. An Oklahoma City police officer that shoots someone today, if an officer shot someone today, they can't talk to him for 48 hours. And that first 40 hours, the reason is because of the things they might say under the emotional process. There's nothing wrong with that, but that same extension of that should go to Jerome Ersland. We also wanted to show, and didn't get to put in on cross-examination, that an Oklahoma City police officer, when confronted by someone that's a danger, is told not to shoot to wound, but to shoot to kill. The judge kept a lot of this out, plus a lot of other things, and we think if the jury had heard all of that, we think the conclusion this jury would have drawn would have been much different than they did.
I'm wondering about the public reaction in the days following the verdict. I mean, a lot of people were either supportive or very unhappy. What did you hear in your office?
We have only received one negative call in the entire time that I've represented Jerome Ersland. One negative. I go around the state. I'm leaving here to go to Shawnee. I'll hear comments there. There all have been positive comments. How could a jury do this? How could anyone? The big thing people ask is, how could anyone actually charge someone with murder in the first degree for this crime?
Are you stunned?
I'm stunned by it. I mean, an old-time lawyer said, you'll win some you shouldn't win, you'll lose some you shouldn't lose. I had no idea. I thought any 12 people that were listening to it, but it said a lot of things were kept out that we thought we would be able to show. Look, here's what an officer does when confronted. This is a man that in 41 seconds took action and was charged with murder in the first degree and was convicted. And yes, I was stunned. I'm still stunned. I wake up thinking about this. I go to bed thinking about it. I think about this case every day. And I try to second guess myself. I don't know what else. I thought if we got to get the evidence in, we would be all right. We didn't. I still thought the outcome would be different.
During the trial, there were some combative moments where your defense team was trying to get in evidence that the judge had already ruled on. Do you think that may have biased the jury against you when the repeated attempts to do that?
I don't know. They've got to know that we'll fight to the last breath for our clients. We didn't want this judge to be the judge. You know, we asked him to be recused. We started off on a bad footing with this judge, and that all played into it, I think. The totality of everything played into this verdict that this jury rendered.
Did you ever get a chance to talk to the jurors to find out what they were thinking?
No, I mean, those jurors, I'm not going I don't ever condemn jurors. The jurors listened to evidence. They made their decision. It was my job to try to get the evidence in to convince them different. And as I said, I think we were cut off at every time we tried to put things in that we thought would benefit Jerome Ersland and make the results beneficial to him.
During the pretrial hearing, you were given the option to have your own experts called if you would have submitted the reports that go along with them. Why didn't you call those experts eventually?
We had tactical reasons for that in regards to that, and that we still believe the judge's decision not to allow us to do that, to limit those based on what we presented, was wrong, and that'll be another appellate issue that we'll have.
Does Jerome have any chance to pardon parole board, do you think?
I don't know. I don't know that. I would hope so, but I don't know.
Do you fear it's become politically hopeful?
Well, I heard the comment from one of the jurors that said, well, they didn't, it was shown that he wasn't moving, that Speedy wasn't moving at the time. Well, of course, we know the video didn't show him at all in the video. I thought the video would be helpful. I thought any person with common sense that heard the law and heard the circumstances and saw the video could come to the conclusion that he did the only thing he could have done in that circumstance, protect himself and others.
In closing arguments, you didn't argue for manslaughter at all.
No, I did not. I wasn't going to cheapen this thing by saying he should have been found guilty of a lesser charge. I thought he should have been walked out of that courtroom, free man, and said, Jerome, you did what you had to do under the circumstances. We all haven't, most of us haven't been in those circumstances, and you did what you did, and there's nothing wrong with what you did based on the circumstances.
Why are you hesitant to say that he may have a chance of pardon and parole? Do you feel like this case has become somewhat politically motivated now?
It has. Of course, it's politically motivated, and I think, there's 5 members. It's going to take 3 of those members to send this thing to the governor, and I would hope the Pardon and Parole Board would look at it. We're going to file for this, this appeal immediately, and we'll decide whether we ask the Pardon and Parole Board to look at it right away or not. I think what they're going to say is we need to go and do our appellate rights before they decide to do anything.
Mr. Box, do you feel that you gave Mr. Ersland the best defense you possibly could?
We do. We did everything we could do. We tried to second guess ourselves after this verdict and said, what would we have done different? And based on what we know the facts were and what was going on, what we tried to get in, we believe we did.
Did you resent people second guessing you a little bit?
No, that's what people do. That's all right. There's a lot of armchair quarterbacks, and until they've been there, know what's going on and know what the circumstances and know all the facts. We had a lot of things, as I said, we thought were very beneficial to our client that didn't get in, and it made it look kind of bad for him. But had we got those things in, the testimony in that we wanted to get in, I think the outcome would have been different.
What about his multiple stories? I mean, obviously that's something that the jury...
Those were difficult, but my thing is, what if he said he was the last great king of Scotland? What difference does it make? That video shows what happened, and that video shows 2 ski mask robbers coming in, threatening and trying to say they're going to blow their heads off. The stories afterwards, I don't think it should have affected the jury. Eventually they did, I think.
The fact there was a petition drive with signatures submitted to the governor's office, what does that say to you about the public?
Well, those people have come in from all over the state. It says to me the public they saw that video and they think, why would they charge someone and convict someone of doing what he did? So I think it's real good. I don't think anyone's ever got 17,000 signatures before for anything like this. So I am heartened by that, and I still have hope. I think we will eventually prevail. Okay, thanks.